And I'm menacing the Commonwealth.
Okay, you're in contempt again. You've already been held in You're in contempt again.
True definition of a black widow. I attest to the defendant's character as one that is evil.
A criminal court judge sentenced an 18-year-old to just 10 years in prison after he pleaded guilty to killing 3 young men, leaving the victims' families heartbroken. Judge Chris Morton from the 230th District Court has been featured in several reports due to his history of granting multiple bonds to violent offenders, some of whom later become murder suspects.
Why did he do that to us?
Relatives of 22-year-old Eric Orduna feel that instead of receiving justice, what they got from 230th Criminal District Court Judge Chris Morton was a slap in the face.
10 years. 10 years? 3 lives were taken.
Judge Morton sentenced 18-year-old Amadal Modawi to 10 years in prison after he pled guilty to causing the deaths of Eric Orduna, 18-year-old Fanan Miesho, and 23-year-old Nick Rodriguez. All 4 were valet workers, but Modawi had been doing donuts and burnouts. He sped off to evade the police and crashed into the others, resulting in tragic deaths.
He was like their shield. Fanan and Nick's shield.
Eric bore the worst of the crash's impact, and his body was tragically dismembered.
Every part of his body.
Eric's mother, Rose Orduna, mentioned that the case was scheduled for last week, but Judge Morton left the court early because his son had been in an accident.
You would think that it would have made a difference. It didn't make a difference. His son is okay. Ours were taken.
Actually, that day that he was taken from us was the last day that I saw him.
Deborah, Eric's aunt and godmother, shared that Judge Morton became emotional and cried during her victim impact statement.
I really thought he was at least going to get 50 or 30, not 10. It's just a slap in my family's face.
I think it's ridiculous. It's not fair for us. It's not fair for the family. It's like he got away with it again. 10 years isn't nothing.
Eric's cousin, Stephanie Guerrero, mentioned that Judge Morton believed Modawi deserved a second chance.
He's young. He has another chance of life. You know, he's going to give him 10 years. You know, what about my nephew? What about Fanan? What about Nick? What about them? They don't have no more chance.
The district attorney's office had recommended a 35-year sentence, but Modawi could be released from prison in as little as 5 years. Inside the 3rd District Court in Detroit, 33-year-old Azura de France hid her face as she listened to her sister read a victim impact statement.
Pray that you find healing, that you actually one day regret what you did to your children, especially Chase, because he didn't deserve it.
In June 2022, police discovered the body of Chase at his home in Monte Vista. An autopsy determined that blunt force trauma to the head caused his death. His mother, Azura de France, was arrested and later pled guilty to second-degree murder. The prosecutor revealed that Chase's siblings had also witnessed some horrific acts.
Not only did 2 of the siblings of Chase Allen witness Miss France putting their brother in a freezer, one of the children, who was old at the time, at Miss France's direction, went and got the laundry bag that she eventually put him in.
The prosecutor added that Chase's mother was not the only one who failed to protect him during his brief life.
He was failed by so many during his short life. CPS. There was at least 7 rejected complaints by CPS, as well as at least 6 CPS investigations.
It was an argument even the defense attorney could agree with.
One thing we can agree upon is this child was failed from every single adult that could have helped him.
France's other children are now in foster care and are expected to need extensive therapy moving forward. In addition to Chase, France had 4 other sons and daughters, all now in foster care. The judge emphasized that France should receive any mental health treatment available while serving her 35 to 60-year prison sentence. Just before the capital murder trial was set to start, Rudy Smith pleaded guilty to a reduced charge of murder. The victim's father had some harsh words for Smith as the judge sentenced him to life in prison. It all began with a brief confrontation in the driveway of a West Side home during the summer of 2016, followed by a single gunshot.
I got up, and as soon as I reached the front door, I heard a pop sound.
Before the sentencing of 40-year-old Rudy Smith, he had pled guilty to the murder of Ruben Sanchez, the son of Sanchez. The victim's father testified, vividly recalling the day of the killing.
I said, "Hey, what's going on here?" And the guys, he had a in his hand, and he went, "Yeah." He said to my son, "I got you."
Smith fled and remained on the run for 3 weeks until Lone Star Fugitive Task Force officers tracked him down. During a shootout with officers, Smith was shot but survived. He was later charged with attempted capital murder and sentenced to 45 years in prison for Sanchez's killing.
Sentence you to life in the Texas Department of Criminal Justice. It will give you credit for time served.
That's not enough, testified Sanchez's father.
I would like to see him get the life or the death penalty.
The prosecutor described Smith in one clear way, calling him a killer without a conscience. In March 2016, Noah Jones was killed by Leon Montgomery, who was dating the baby's mother at the time. Over 2 years later, Montgomery appeared in court, awaiting sentencing on manslaughter and criminal abuse charges.
These injuries, how this child was treated, are just, it's absolutely inexcusable.
Before delivering a 30-year sentence, Judge Audra denied Montgomery's request for a new trial. It was at that moment that Montgomery's outburst started.
And I'm menaced the Commonwealth.
Okay, you're in contempt again. You've already been held in You're in contempt again.
What y'all doing here is wrong to people.
And that'll be 6 months to serve when you finish serving in
No,
this
6
case.
months. I got 30 years. Everybody here get.
Control yourself. I'm going to remove you from the courtroom.
After Montgomery was escorted out, his attorney tried to have the contempt charge dismissed.
I understand Mr. Montgomery is upset, and I would like to apologize for him.
However, the judge also denied that request, stating it wasn't Montgomery's first offense.
He, again, has shown zero respect for the law, no remorse for a child in this case, and there is absolutely no reason for the court to continue to tolerate the outburst.
Montgomery will serve the recommended 30-year sentence for the death of Noah Jones, along with an additional 8 months for 2 counts of contempt. A Cleveland man, Edmund Benson, remains in jail after appearing in court in connection with the tragic death of his daughter, Neve Benson, affectionately known as Nene. She passed away after, according to family members, getting hold of her father's gun. In court, Benson's expression showed the deep regret of wishing he could turn back time and prevent his gun from ending up in the hands of his precious daughter. As he faced the judge, Benson initially went through the motions, confronting the charges related to the heartbreaking incident where Neve accidentally herself in the face.
What's his relationship?
And that's when the reality hits. A father whose daughter is gone, not because of a stranger, a criminal, or an illness, but because she managed to get her small hands on a gun. Their hands were barely big enough to hold it, yet she got hold of it and tragically shot herself.
We all hurt. We miss her. We miss her, man, every day, man. We can't stop crying about this.
Outside the home where Neve tragically lost her life, the family has created a makeshift memorial. A candle still burns brightly, and a teddy bear symbolizes the love they have for a child gone too soon. The family remembers Neve as a bright and amazing little girl.
Nene was a good girl.
Good girl.
She had such a huge heart. She cared about everybody. The first day I met her. Auntie.
Nene dreamed of becoming a boxer when she grew up, but tragically, she lost her fight this past Saturday. The family shared that she had gone upstairs to get something for her sister, but never returned.
We didn't hear no. Y'all gotta believe it. It was no sound. It was none. All we heard was somebody fall on the floor. We ran upstairs. First, her daddy ran upstairs, and he started screaming and help, and we all ran upstairs.
Edmund Benson was not legally allowed to have a gun due to previous felony convictions. Currently, he remains in jail with a $10,000 bond. 2 brothers were sentenced in Muskegon for their involvement in the death of a girl and for shooting at officers who were investigating the incident. It was an emotional day in court as the victim's mother spoke. Now, the person responsible for taking her daughter's life is facing a lengthy prison sentence.
You used to be cool in high school. If I would have knew you would have had my life like this, I would have never said 2 words to you.
On April 7th of last year, Adorn Malone was tragically shot at a home on East Isabella Avenue near Ransom Street. The person responsible for the incident was 22-year-old Julio Casiano.
I gotta deal with that for the rest of my life. I don't get to see my daughter. I don't get to do her hair and dress her up like her sister. I don't get none of that. You took that.
This year, Casiano pleaded guilty to charges including second-degree murder and felony firearm possession. He also pleaded no contest to a gang membership charge.
The defendant was in a street war with people of his opposing gang, rival gang members, young people like the defendant. And one is someone, and then someone gets shot, and then they got to fire back.
Before being sentenced, Julio Casiano apologized to Ador's family for the heartbreaking incident.
It was different. If I could go back in time and change the things that occurred that day, I would.
However, the judge ultimately sentenced Casiano.
This is a horrific loss. Because you are upset because somebody was making fun of the fact that you got shot or somebody you know got shot?
Tally Hatcher, the 26-year-old brother of Julio Casiano, was sentenced to 12 years for charges including assault with intent to do great bodily harm and gang membership. The judge used the sentencing as an opportunity to call for an end to the violence affecting the community.
It could get worse than 14, 13 getting killed. 6 gets killed. It needs to end. And somewhere, somebody needs to start.
Casiano was sentenced to 28 to 80 years in prison. Mary Diaz has been sentenced to 25 years in prison after accepting a plea deal for the murder of her boyfriend, whom she shot in 2020.
So cruel, and just leave him there.
That's Teresa Felix speaking to the woman who killed her nephew, 58-year-old Christopher Jones. His body was discovered decomposing in his home in February 2020. Months after his death, his pregnant girlfriend, Mary Diaz, was arrested and charged with his murder.
Not only did Miss Diaz shoot Christopher Jones in the back, she left him to rot.
The state argued that Mary Diaz took Christopher Jones's credit cards and used his phone to text his family, pretending he was fine. Her defense attorneys requested a sentence shorter than the recommended 25 years, citing that Diaz has 6 children and acknowledges her wrongdoing.
The state wants you to believe that she just left him there and did nothing regarding the police, but in fact, she tells the court through the PSI that she thought the police had been notified through these people, because she goes immediately and tells somebody what happened.
Judge Stephanie Boyd followed the state's recommendation and sentenced Mary Diaz to 25 years in prison as part of the plea deal. After the sentencing, family members appeared via Zoom to deliver victim impact statements, sharing with Diaz how difficult life has been since Jones's murder.
We lost a big piece of our family. Hope God has mercy on your soul, that you understand what you have caused.
Diaz showed no reaction as she stood and listened to the victim's impact statements. Afterward, she was escorted out of the courtroom and will eventually be transferred to prison. She will be eligible for parole after serving half of her 25-year sentence. After the tragic murder of her husband, Maria Ingenza now faces the unimaginable situation of grieving for her spouse while her son is behind bars, charged with the crime. Maria had to endure a painful half-hour in court, where she was questioned and forced to relive the day when her husband was killed. She vividly recalled the moment police placed handcuffs on her 21-year-old son.
They told me your husband is under the bed.
Eugene Chiambo had his preliminary hearing for the shooting and killing of his 68-year-old father, Imbe Ingenza. According to Henderson police, the incident arose from an argument. People who knew Eugene described him as a quiet and innocent student who may have struggled under his father's strict rules. In court, Eugene's lawyer portrayed the victim as an oppressive authority figure, suggesting tension between the two.
He not only ran the household, he ran
everyone's life that lived in the house.
Eugene's mother confirmed the portrayal of her late husband as controlling. She explained that he didn't allow her to drive and forbade her and their son from having friends. For the first time, Kelly Phillips, also known as Kelly Lashow, appeared before a judge in connection with the death of her daughter. She is now facing charges related to her child's death. Phillips was also appointed a public defender after her previous attorney, Jerry T. Donahue, had to step down. Donahue later spoke to the media, explaining why he withdrew from the case. Phillips remains at the Las Vegas Detention Center, but Donahue mentioned she will be transferred to CCDC soon. Despite no longer representing her, Donahue stated that he still believes she is a victim in this case and questioned whether prison is the right place for her.
She is a woman that was being controlled, and she felt pretty powerless. Every time she stood up to him, he would go into a rage.
Kelly Phillips's former attorney, Jerry T. Donahue, stated that Phillips was unaware of the tragic circumstances involving her daughter and her family until days before she turned herself in to North Las Vegas police.
She reacted like any loving parent would react when you get the news of a child. She broke down, she cried.
According to Donahue, Kelly described a grim life under Lashow's control, stating he was abusive and controlling and kept the entire family isolated. Donahue shared that Kelly told him the couple, along with 5 of their children, left their North Las Vegas home 5 months ago, not 8 months as the arrest report claimed. Kelly also mentioned that Lashow insisted on leaving the kids behind and became violent when she tried to argue against it.
I speculate that 17 and 3-year-old were left behind simply because of the violence that occurred against the 17-year-old.
Donahue believes that Phillips is truly a victim. He even offers to take on her case pro bono, but he explains that her family is unable to cover the basic costs associated with litigation.
I can't come out of my pocket for hard costs. I have little children to support myself. It could easily, in a case like this, it could easily be $5,000 or more for hard costs.
A judge set the preliminary hearing date for April 23rd, though Donahue believes the case may eventually go before a grand jury. There was an emotional scene in court as Connie Eskelsen was sentenced to 21 years in prison for attempting to poison her husband. During the sentencing, she was referred to as a black widow and a witch doctor. At 68 years old, this sentence could mean she will spend the rest of her life in prison. Back in August, a jury convicted Connie of trying to murder her husband. Her husband, Randy J. Eskelsen, survived the poisoning, and a Maricopa County judge delivered her sentence. In August 2017, Connie found Randy unconscious, face down, in their cave home. His liver was failing, and he had little to no brain activity. She called 911. Randy, who had been married to Connie for 35 years, never suspected her, but his adult sons did. In court, Randy's sons, Randy Eskelsen and Brian Eskelsen, spoke out about their stepmother and the impact of her actions.
True definition of a black widow. I attest to the defendant's character as one that is evil.
It took the family nearly a year and a criminal investigation before they began to suspect Connie Eskelsen. Now, with her conviction behind them, the victim's adult sons stood before the judge, asking for no mercy in her sentencing.
We have spent 35 years in her prison, and we are asking that you give her the maximum sentence of 21 years. She simply cannot be trusted or given a second chance.
As for the victim, Randy J. Eskelsen, he slept next to his wife for months during his recovery, unaware that she had tried to kill him. In court, he revealed that his health problems persist and that he has since been diagnosed with prostate cancer.
Sometimes I can't remember what I'd done yesterday.
He, too, expressed his desire for his soon-to-be ex-wife to spend the rest of her life behind bars.
She knows where I live, she knows where I work, and I'm scared to death.
Connie Eskelsen, for her part, continued to maintain her innocence. She stated that she still loves her husband despite being convicted of attempting to kill him.
He's always been my best friend and soulmate for 35 years. I would have never purposely harmed my husband in any way.
Connie Eskelsen received no leniency from the judge. She was sentenced to 21 years in prison, the maximum sentence for first-degree attempted murder. A Lynn man, Zachary Vozella, appeared in court, accused of killing his brother's pregnant girlfriend. Inside bags of belongings Vozella had removed from the apartment where he had been living with the victim and his brother, who were in a relationship. The tragic killing of a pregnant mother has left many questioning the motive behind this horrific act.
You're charged with murder.
26-year-old Zachary Vozella has been charged with the murder of his brother's pregnant girlfriend, 25-year-old Brianna Welsh. Her body was discovered in a Lynn apartment where she had been living with the brothers, following a well-being check requested by her mother.
Brianna was discovered in her apartment. As a result, there appeared to be multiple sharp force injuries.
Prosecutors stated that Zachary Vozella, who had been homeless, was in the apartment when his brother Brendan allegedly assaulted Brianna Welsh. Brianna received treatment at a local hospital and was later released. Initially, Zachary claimed he hadn't seen the victim again after that, but he allegedly changed his story later.
This defendant indicated he'd actually been at the apartment on the Linway from 2 p.m. until 8:30, but claimed he never saw Brianna, which is contradicted by the cab driver who drops her off at about 6:10.
At the time of Brianna Welsh's death, Zachary Vozella's brother was in police custody for the assault charge. Lynn police obtained surveillance footage showing Zachary arriving at the apartment with bags of belongings. Despite this evidence, Vozella's attorney urged against a rush to judgment.
He's very, very sad about the whole, not only his own circumstances, but that someone and that his brother's in trouble. So everywhere he looks, it's just sadness.
And he's denying that he's responsible.
Yes, ma'am.
Brianna Welsh, who grew up on Cape Cod, is remembered by those who knew her as a kind and caring person. A former teacher, by her tragic murder, expressed disbelief, describing Brianna as someone with a good heart.
Anything for anybody. So I think that's the impact that she had, and that's why I think people are struggling to process this.
Prosecutors stated that it appeared Brianna Welsh wanted her boyfriend out of the apartment following the alleged assault and had wanted Zachary Vozella out even before that incident.
There's no indication right now that why something like this should have happened.
Prosecutors revealed that Zachary Vozella initially claimed he never had a key to the apartment. However, 2 keys were found inside the bags of belongings he removed. Despite having no criminal record, Vozella is now being held without bail. A woman, LaTarsha Sanders, will spend the rest of her life in prison after being found guilty of murdering her 2 sons in 2018. She was sentenced to 2 mandatory life sentences for the first-degree murders of her young sons.
I'm going to impose the mandatory life sentence on both counts.
The defense attorney argued that LaTarsha Sanders was insane at the time of the murders. They also mentioned that several family members were not in favor of the life sentence, but the children's father supported the mandatory sentence and requested it in court.
The pain of the father, the sisters, the brothers, aunts, uncles, grandmother, that pain falls on their hearts every day, and that's a life sentence for them.
LaTarsha Sanders was arrested in February 2018 and charged with the murder of her 2 sons. After a 9-day trial, she was found guilty of 2 counts of first-degree murder and 1 count of witness intimidation.
The thing we need to remember about is the 8-year-old boy and the 5-year-old boy. They're babies. And nobody deserves to die that way. They're innocent, and their lives are gone forever.
When police arrived at the house in 2018, they found LaTarsha Sanders distraught outside. Instead, she reportedly cleaned up the crime scene afterward. Believed to have been used in the killings, was found in the kitchen. Sanders plans to appeal the sentence. In addition to the life sentences, she is also facing 9 to 10 years in prison for witness intimidation. On October 8th, 2022, in Las Vegas, rapper Jamal Porter fired shots outside a club, setting off a series of illegal events now at the center of a courtroom drama. Instead of performing on stage, he faces the consequences of his actions in court today.
I don't necessarily think that the $75,000 bail is inappropriate. I think $50,000 would also be appropriate. He does live in Los Angeles. He's willing to agree that he would only come to Las Vegas for the purposes of resolving this court hearing in this case. So if the court wants to set that condition, that is fine. But otherwise, I submit to the court. I think $50,000 is equally appropriate.
Okay, thank you. I have to take into consideration a number of factors here. There does appear to be an indication of employment that was mentioned in the request for an arrest warrant. He was arrested on an outstanding warrant on a much less serious case. He is likely to be released at the age of 25. He appears to have a minimal history, if any. Looks like an arrest in 2016 and a misdemeanor conviction. It looks like he's got a number of people supporting him in the courtroom today, including, I've been told, a fiance and some friends and some business associates.
Yes, that's perfect.
Thank you. I am going to set bail in this case based on the nature of the charges. The allegations are quite serious and could have been much worse. $50,000 is a reasonable amount of bail. Bail will be set in the amount of $50,000 cash or surety. It's likely that Mr. Porter is going to make that bail amount. Upon his release, he is ordered to comply with standard conditions of release. He's ordered to stay away from and have no contact with Cantabious Trailer, the alleged victim of this case. Obviously, that shouldn't be a problem. Mr. Porter, you're advised, and you will be advised in writing, that if you violate that order through any means, including third parties or any other means, that would likely revoke your release, or there could be other penalties. You must stay out of trouble. That's a condition of anyone's release. Of course, stay in contact with your attorneys, and of course, make the necessary court appearances that they advise you to make. If you fail to comply, a warrant for your arrest could issue. You would face extradition back to the state of Nevada from California or wherever else you may be found. You understand everything, Mr. Porter?
Yes. Cantabious Trailer, Kentab as in boy, IUS, last name Trailer, TRAYLOR.
And Mr. Trevor, what is your testimony today for the court?
So first of all, I just want to start by saying thank you, Judge. I'm just completely disappointed in this complete process, actually. From the DA to his representation, to him, to everything. It's just all been a complete drop of the ball on my end. I have complete lost faith in the justice system. This crime has done nothing but take a toll on my life since the day it happened. I haven't been able to get work. Everything has gone down the drain. I just feel like this has not been done on my case. I mean, this hasn't been done on my behalf. I know people who get more time for stealing bubble gum, honestly. I know people who do more time for stealing TVs than they do for shooting somebody. I'm just completely disappointed in all of this. I hate the way my name was ridiculed in the social media before I could even find out about it. Like I said, just this complete process has been a complete drop of the ball. That's all I got to say about it. It's a complete drop of the ball, and that's it. It is what it is.
And Mr. Trailer, I really appreciate you expressing the frustrations that you have, and I know that the outcome here today won't change that because what the negotiation is has a certain range of sentence and a certain
but even that, like I said, I feel like those terms and conditions, I know myself included, would have more than that for domestic violence, for this or that. He has this going over multiple states, multiple this, multiple that. You guys are arguing semantics on, can he come here to make money? And so he doesn't deserve to be here. He doesn't deserve to be out and walking around. He doesn't deserve any of that, honestly. But because he has a little bit of money and a little bit of a name, you guys are going to give him that, and that's okay. But just at the end of the day, like I said, I just want to say my piece, and like I said, I'm completely disappointed in all of this.
Understood. Mr. Trailer, and I'm not trying to convince you anything otherwise, and I'm not having a dialogue with you here. I'm just trying to give you the wrap up here that we are going to conclude this case. It sounds like you have another process pending. So
but that has nothing to do with how I feel about this in general.
Again, not a dialogue.
I'm
just sharing some information with you, okay? I understand that. I'm not trying to convince you of anything different. I'm trying to tell you that we're going to complete this process here today. To the extent that it closes out this process, good or bad, obviously bad from your perspective, it will close it out. And I hope that you'll use the other process to find whatever relief it is that you are seeking, not meaning whatever I presuppose any outcome there, but just that there is another avenue. And the court is going to act within the parameters of what it has here and bring this matter to a close. But I can assure you, I'm not giving anybody any breaks because of any status they have or money they have. I'm working within a system and within a negotiation, and I trust my counsel to make negotiations for reasons, and I appreciate that that's not going to sit well with you. I just thank you for your time here today and letting us know how you feel about it.
Yes, ma'am.
Because that's important.
Yep.
Thank you, Mr. Trailer. You may take your seat if you wish to stay. Someone who has some prior history may be familiar already with some of those things. But the main point that I have for you here is the weapons. You know you cannot have guns. There's no confusion on that point. And if you choose to roll And that's your choice, but I will tell you, if you get caught doing that, you get brought back here on any kind of probation violation, especially anything involving, I will not hesitate to put you in prison for a significant period of time. You are playing with your liberty, your life, obviously, but you're playing with your liberty if you're gonna have and do anything that's gonna violate your probation in that regard. Do you understand?
Yes, ma'am.
I don't want there to be any confusion. I hear people who say things about, I didn't realize I couldn't, do this or that or have pictures with them or whatever. No, zero around you where you are of any kind. And that needs to be quite clear. Somebody just handed me the order out, and it looks like Sahara to Russell does not cover downtown. So I'm gonna account for that. So I'm gonna adjudicate Mr. Porter this time guilty of discharge firearm at or into occupied structure via aircraft or watercraft. His underlying sentence will be a minimum of 24, maximum of 60 months in Nevada Department of Corrections, suspended with probation not to exceed 36 months. He will have to pay the $25 return assessment fee, $3 DNA collection fee, $150 DNA analysis fee. As we noted, no restitution being requested. We do have, I'm not going to impose a fine. I do have the standard conditions of probation, as I noted, including any requirements applicable. Special conditions will include, and we'll just start there because that was the discussion, that he is ordered to stay out of the strip corridor. And he's also ordered to stay out of any gaming facility, institutions, or what would be indicated as the downtown corridor, the equivalent of the strip corridor. So effectively, and again, until he interstate compacts, he can only be in those areas if he has work application or some other legitimate basis to be there, not as a pastime, as a just killing time in the areas in any way, shape, or form. And so the order out is for the strip corridor and the downtown corridor. We will also require him to have no contact whatsoever with Mr. Traylor or his family. I appreciate that it sounds like others are having contact. I'm not going to say on your behalf, but directly, you're directing it, but clearly that's happening. To the extent that there can be any effort to ensure that Mr. Traylor is not being harassed for this situation or having contact, so be it. But your obligation is no contact that you initiate or that you initiate through anyone else by any means or medium of any kind. We want you to understand that I think impulse control counseling would benefit here as well to make better choices in the future in these circumstances. No use, possession, or control of alcohol or drugs that includes marijuana. I take that very seriously for all probationers, so we have compliant probation. I want you to have structure to your probation, so full-time employment is required to comply with any curfew that may be imposed, report within 48 hours, so no later than Wednesday, to the probation department to get started on the process. Do not take for granted that you need to be doing all of these things and that somehow someone's going to look the other way on that. You need to report, and you need to be compliant at all times. And in addition to the standard search clauses, I have one special search clause that any digital storage media that you have access to or use, including computers, handheld communication devices, network applications, associated with devices, social media, remote search services are all subject to search. You must provide all passwords, unlock codes, and account information associated with those items with or without a search warrant at the request of Division of Parole and Probation or its agents. As to the count 2 adjudication, that is the battery misdemeanor. I'll send this magistrate give you credit for time served, so your probation's only moving forward on the one count. But you do have a significant sentence hanging over your head. It's not the max the state asked for, but it is still significant. I'm not undermining any of your prior history. I'm looking at this case and the circumstances as I understand them, but I do want to be clear that, again, I will not hesitate for you to spend a significant amount of time in prison in the state of Nevada if you do not comply with this probation in all respects and you do not stay away from those weapons and any of that comes to light for us, all right? I think the other counts were already dismissed out of the negotiation, but to the extent counts 1 and 3 had not been dismissed, I believe those should be dismissed today.
Yep.
And then if there were any, other counts found over prior to that, those would also be dismissed today. Is there anything that we did not cover?
I don't think so, Your Honor. Thank you so much.
I had a bond.
Oh, yes.
Bond. So yeah, didn't forget that. Thank you for the court catching that.
In June 2016, in Buffalo, Mark Dano attacked his ex-girlfriend and her father. Though they survived, justice will ensure Dano faces the consequences of his crime. Typically, courts allow defendants a final statement before sentencing, but this case is different. It remains to be seen if he will take this opportunity or not.
Yeah, I do. I have a lot to say, and I'd like to get at least a little bit comfortable, as I've been mistreated throughout these last 700 days of incarceration over at the Erie County Holding Center. On top of every other double standard. What's going on here? Well, it's kind of disturbing they didn't have that happening to them. But yeah, I can you shut the one off that's, but I think, try that. Is this better? Testing? I heard all the their statements, and you know, I am sorry. I am sorry, but what took place to put someone to torment, to put someone into that particular mindset, has to do with lies. One lie after another, after another, after another, after 9 years of protecting Gina Tirana. Okay, listening to her problems. And they were addressing you, and I want to address everybody. I was there for her through her issues with her ex-husband. Oh, okay. Address the court. All right. I was there when she was being beaten by her husband, threatened. She wasn't even divorced. I was threatened by this man. I had to stand. I could have taken a and I would have taken a for her at any particular time, or the family, for that matter. I was always there to help them. Okay? I loved them. I absolutely loved them. I thought this is going to be it. This is going to be my life with this woman the rest of my life. And I look forward to aging gracefully and building a future. Her life was a shambles, and a shambles like you wouldn't believe. And I took it brick by brick and rebuilt her life, rebuilt my life, showed the love and care and support. And then what happens is, in a relationship, lies. And she knows that I had a lot of issues with my family, with my mother in particular. And she knows how these order of protections worked. And on May 2nd, she decided to go into court and pretend and lie, when she had been to court earlier for her own husband to put an order of protection in, who is a corrections officer on top of it.
Well, welcome to state corrections. Buddy.
State corrections.
Step out, sir.
And I even received a threat when I even was incarcerated right off the bat from somebody at Attica. But to get back to the lies, lie after lie after lie. And that's torment. And then to be arrested, to get a warrant in the mail, to throw you over the edge for 10 minutes, or maybe 20 minutes of my life, okay? I sat there and I'm like, I'm getting arrested for going to a restaurant. And she didn't call 911 that minute, because I didn't do anything except have a meal with another person. She was there with her girlfriend. She went in there 10 days later and filed a report. She didn't call 911. There was never any threat. I wasn't harassing her. We were working together over at Chase as ushers the whole time. Still in a relationship. But 2 weeks later, she goes and puts an order of protection in because of an insurance fraud that I had caught wind of when we went to the chiropractor and she happened to be there, that she was running. And I says, look, that's insurance fraud. And then she decided, well, I'm going to get an order of protection. I'm going to connive with the Amherst Police Department, because Mark's got a problem with the Amherst Police because his mother's had problems with them over there at the Amherst Police. So they utilized, and manipulated the law, because that's what order of protections are, nothing but a manipulation. That she can't be questioned about her lies and her deceit. That's the one thing the family I noticed after being with them for 9 years. A lie is okay as long as you can go to Sunday church and pray about it. It's okay that my son had 5 DWIs, has never gone to jail, and the other ones had 3 DWIs. addict, got his head beaten in, and they've been in and out of courts of almost every type of relationship, okay, through the years, 27 children. I couldn't even tickle Gina at a certain point because she says I was been touched inappropriately by her husband, by her father. That on top of it, that she was 16 years old when she had a pregnancy, okay, and she had problems with her home. So I took all that too on top of my shoulders. Never spoke another word of it. But then she had the audacity to go to the police and lie to them while we were still working together, while we were still doing things together. And I remember one last text, she put like a little bomb and a snake on it towards the end. And when I got the order of protection in the mail, I obeyed the order of protection. I obeyed it. But she made up another report. It's a disgrace. This whole democracy, this whole justice system is a disgrace. That my attorney didn't do the things that he needed to do to show the discrepancies in the police reports, their statements. They had prepared statements. I've had no pen or paper. My glasses have been taken away. I don't even have underwear or socks. I've been tortured in that jail, attacked, and no one does anything about it. You don't know anything about it. You probably have never taken a walk through the tunnel. Why? Maybe I know what Jesus Christ walked over 2,000 years now through. I'll tell you one thing. They were out and about, and neighbors have seen them out and about. And they've been doing their activity, and they're going to have 100% recovery, I'm sure, once you sentence me to whatever many years you're going to. I will be appealing it, as I said I would. I have had no rights. My rights were violated. That's what we fought a revolution for. That's what we had rights for. I didn't go 52 years without getting in trouble, staying within the law. Yeah, I'd protect myself. When you have to protect yourself, you don't have to do that, Your Honor. You just slam that mallet right down. And you've been doing it to a lot of people, and men in general, without giving any respect to a defendant. I asked for my attorney to be replaced because he wasn't doing what he should have been doing. Okay? And you didn't respect that either. And I gave you plenty of reasons that he wouldn't call witnesses to attest that she was lying. Have you ever been arrested for something that you didn't do? That's torment. That's torment. You don't torment people that aren't committing crimes. But the law today, they'll take any statement, anybody that walks through that door, they'll take a statement and manipulate it. Get down to family court. You'll get your order of protection. Then all you have to do is give us a call. I've had no time to prepare. No time. I've been, I'm telling you. It's been an experience. I'll tell you right now, a coward, these cowards that lied could never have gone through what I've gone through. And I'll continue to go through it. But I am sorry about their injuries, but they are overblown. Because they've been seen out. They've been cocktailing and dancing. But I couldn't bring those people in. But you were going to bring in a bad act of someone that I never even talked to about the situation. Another sworn affidavit. People can swear on oath, can't they, Your Honor? It happened to a juror who swore the day before that she would say, I'll do this. I'll be a juror, and even though I have doubt, but I'll do it. But she called you that night as well as somebody else. People can lie on oath. They can swear on oath, and they can say they're going to do this and they're going to do that, but they're going to, and then they don't have to have any ramifications. No ramifications at all. I have no way of challenging anything. I have to go through the due process with no due process.
It's noteworthy that the pre-sentence investigation report reflected something that I think came to a surprise to all of us. That you actually had been convicted in 2001 of 3 counts of assault and battery in Massachusetts involving a rejection by a female and 2 witnesses that came to her aid. So you just told me you didn't get in trouble for the first 52 years of your life, and that was not accurate. You also reviewed the sentencing memorandum that was submitted by your trial counsel and the responding memorandum that was submitted by the people. Not surprisingly, they differ in their interpretation of the requirements of Penal Law Section 70.25, something which Mr. Grasso made reference to moments ago. It concerns the statutory application to multiple sentencings that are being imposed at the same time, like we have here today. For the purpose of the record, I'm going to briefly review the chain of events reflected by a reasonable view of the evidence that I observed from the trial in this matter that resulted in 9 guilty verdicts, for which the court is now required to pronounce sentence. It is this view of the evidence that supports this court's application of Penal Law Section 70.25 today. At trial, it was established that on June 6, 2016, that you unlawfully entered the dwelling located at 345 Mill Street, Gina Tirana's home. When you entered, you had a short-handled sledgehammer wrapped in plastic bags, and you entered there with an intent to commit a crime therein. You walked through the home, to the rear of that home, and you exited the dwelling into the victim's backyard and onto the deck where the victim, Gina Tirana, and Todd Russo were standing outside in their backyard. Ms. Tirana was on the deck. Mr. Russo was standing on the lower portion at ground level, or lower patio. It was at that time that you began striking her, Ms. Tirana, as she stood on the deck. You struck her about the head and body with a hammer, and she fell to the floor at the outside deck. After Ms. Tirana fell, stunned and on the ground, you stepped down off the deck and began Mr. Russo about the head with a while you were striking Mr. Russo, Ms. Tirana somehow managed to crawl back into the house, the dwelling. That was in her effort to call for help. After Mr. Russo multiple times in the head with a you then re-entered Ms. Tirana's home through the rear patio door, where you apparently found her and began striking her again in the head with a leaving her for in the hallway that led to the driveway side door of the dwelling. You then exited the home, returned to the rear outside deck, and resumed Mr. Russo in the head. And you only retreated after being kicked by Mr. Russo, as Mr. Russo lay on the ground. You then fled the scene, leaving behind the sledgehammer and 2 plastic bags that you had the sledgehammer wrapped in. Shortly thereafter, you drove apparently to 115 Catherine Street, or you arrived there somehow, and that was Ms. Tirana's parents' home. You entered that home unlawfully, armed with a garden shovel. You immediately located Ms. Tirana's elderly father, Michael Caputi, inside that home, and you struck him with his arm in 2. There is a $325 mandatory surcharge, crime victim assistance fee that must be imposed. This sentence will run consecutive to counts 1 and 2. As this court finds that your actions in committing this crime, as I just reviewed, were separate and distinct from the actions in count 1 and 2. And I note for the record to see Court of Appeals decision People v. Brainy at 29 New York 3rd 10, Court of Appeals from March of 2017. Count 4, attempted murder in the 2nd degree regarding Todd Russo. This court imposes for violation of Penal Law 120.25, subdivision 1 is modified by 110. The court imposes a determinate 25-year sentence with 5 years of post-release supervision. There is a $325 mandatory surcharge and crime victim assistance fee that I must impose. And it shall run consecutive to counts 1, 2, and 3. Count 5, aggravated criminal contempt in violation of Penal Law Section 21552, Subdivision 1. This court imposes an indeterminate state term of 2 1/3 to 7 years. There is a mandatory surcharge, crime victim assistance fee of $325 that I must impose. It will run concurrently with counts 1 and 2 and consecutive to counts 3 and 4 pursuant to Penal Law Section 70.25. Count 6, burglary in the first degree regarding 115 Catherine Street. That's the computing home. This court imposes a determinate state term of 25 years with 5 years of post-release supervision in violation of Penal Law 140.30 Subdivision 2. There's a mandatory surcharge and crime victim assistance fee of $325 that must be imposed. This sentence shall run consecutive to counts 1, 2, 3, 4, and 5. Count 7, burglary in the first degree in violation of Penal Law Section 130.30 Subdivision 3, again regarding 115 Catherine Street. The court imposes a determinate sentence of 25 years plus 5 years of post-release supervision. There is a $325 mandatory surcharge, crime victim assistance fee that this court must impose. This sentence will run concurrent to counts 6 pursuant to Penal Law Section 70.25 and consecutive to counts 1, 2, 3, 4, and 5. Count 8, assault in the second degree regarding Michael Deputy in violation of Penal Law 120.05 Subdivision 2. This court imposes a determinate state term of 7 years with 3 years of post-release supervision. There is a $325 mandatory surcharge, crime victim assistance fee that must be imposed. This sentence shall run concurrent to counts 6 and 7 pursuant to Penal Law 70.25 and consecutive to counts 1, 2, 3, 4, and 5. Count 9, assault in the second degree in violation of Penal Law Section 120.05 Subdivision 12. This regarding Michael Deputy. This court imposes a determinate sentence of 7 years with 3 years of post-release supervision. There is a $325 mandatory surcharge and crime victim assistance fee that I must impose. It shall run concurrent to counts 6, 7, and 8 pursuant to Penal Law Section 70.25 and consecutive to counts 1, 2, 3, 4, and 5. I would also note this court recognizes that the post-sentencing will be reduced by statutory fiat. I'm also issuing an order of protection for 83 years from the date that he went into custody, which I believe is June 6th of 2016, on behalf of Gina Tirana and Tom Russo, which reflects the 75-year sentence plus 8 years by statute that relates to the crimes associated with them. I'm also issuing an order of protection for 33 years on behalf of Mr. and Mrs. Deputy, which reflects the time that is statutory maximum the court can impose of 25 years plus 8 years is statutorily determined through the civil criminal procedure law. That's the duration of the order of protection. Again, that will run from the date that Mr. DeBlino went into custody, which is June 6th of 2016. These are being imposed, these court orders of protection pursuant to Criminal Procedure Law Section 530.12 and 530.13. People have the order of protections or orders of protection available here right now.
This case centers on Danielle Redlick. In January 2019, Danielle ended the life of her husband, Michael Redlick, at their home in Winter Park near Orlando. The police investigation uncovered her involvement, leading to charges being filed against her. After reviewing all the evidence, the judge determined an appropriate punishment for Danielle.
You stated you did not wish to make a statement, correct? Ms. Redlick, you testified at trial that you killed your husband, and the jury has found you not guilty of that conduct, and I will not sentence you based upon that conduct. You further testified that after you were scared and didn't know what to do and you froze, and the evidence shows that there were over 10 hours where you waited before you called 911 and gave varying stories as to the cause of Mr. Redlick's. But you stand before me today for your conduct during the time between Mr. Redlick's passing and the 911 call made on the next day. And it is that conduct for which you are going to be sentenced today. According to the crime scene pictures and evidence were smeared throughout the home. You used bleach and other cleaners to clean what looked like a horror scene. Crime scene photographs also showed where you left the cleanup towels and a bucket of colored water. The pattern expert testified that typically patterns could tell a story or explain the circumstances surrounding a homicide crime scene like this, but not so in your case. The expert also testified that as a result of your conduct, it was virtually impossible to determine the exact circumstances surrounding Michael Redlick. The scene was tampered with so much so that evidence was of little to no value to determine what happened between the night of January 11th of 2019 and mid-morning, January 12th of 2019. Conduct for which the jury convicted you, tampering with physical evidence, deserves more prison time than you have served. But the law does not allow me to do that, and I will not sentence you to a prison sentence. You have already been adjudicated guilty of count 2, tampering with physical evidence. And so for that conduct, I will sentence you to 364 days in the Orange County Jail with credit for 364 days time served. That's going to be followed by a period of 12 months of probation. You will report to probation by 3 p.m. The office is on the 7th floor beside courtroom 7B. Within the first 30 days, you will sign up for and you will submit to a mental health evaluation and complete the evaluation and any required treatment within 12 months. I will impose court costs, and there is also a public defender lien that should be imposed.
Court costs of $418.
Mr. Parnell and Ms. Conlon, for the public defender lien, what do you feel is an appropriate cost for your services for the trial and the litigation?
Judge, she's been in jail for 3.5 years on this. She needs to spend her time and resources on rebuilding her life and her family. So we'll be asking for the defaults $100 for the public defender lien.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.